Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Good afternoon and welcome to a virtual session of First Court of Appeals, District of Texas. We have one case on today's docket. That is cause number 01-20-00418-CV, Albert G. Hill III versus Lisa Blue et al. May we have the appearance of counsel on behalf of the appellant, please?
Your Honor, Brian Antwile and Matt Bushy on behalf of Albert Hill III.
And on behalf of the appellees?
Good afternoon, Your Honors. This is Jeremy Martin. I represent appellees Lisa Blue, Charla Aldous, and Steve Maloof. With me is Paul Koning, who represents the appellee Mike Lynn. And also with me is Sean Long, who represents the appellee Jeff Tillotson. And I think the court may have seen our letter. What we've done is Mr. Koning has reserved 4 minutes to talk about attorney immunity and release. And Ms. Long has designated 1 minute just in case the court has a question specific to Mr. Tillotson. She wants to be able to answer it. And they've both agreed that if the court doesn't use the time with them that they've designated, that they will cede their time to me, which I then hope to cede to the court. And all of that is subject to the court's approval.
And that is fine by us. And for the appellant, I understand Mr. Antwile will give the case in chief for 12 minutes, and Mr. Bushy will rebut for 3 minutes.
That's correct, Your Honor.
All right, then. We will move everybody out but Mr. Antwile. And as soon as that happens, all right, Mr. Antwile, you may proceed.
May it please the court, and good afternoon, ladies and gentlemen. Your Honor, I know we talked about questions, and I know you have some. I was going to ask the court's indulgence to take a couple of minutes to do a bit of an overview here, and then open it up, if that's okay.
Well, actually, before you get into the overview,
yes,
we have a lot of names here in the caption of the case, and in particular, I'm wondering, what's the status of Justin Campbell, Robin Harrison, John Dagley, Suzanne Gross, Campbell, Harrison, and Dagley, Norris and Weber, FKA, Callaway, Norris, Burdett, and Weber? Are they parties to this appeal? Were they severed out?
they're out of the case, Your Honor. Completely out.
Was there a severance order signed?
Say again?
Was there a severance order? Or
honestly, I don't know, Judge. I wasn't a trial court lawyer, so I'm not familiar with exactly what happened with those individuals.
Okay, but they're not in this appeal.
No. All right.
Okay.
It's sort of a unique position here because this is your second bite at the apple and my third. I've listened to 3 arguments. This will be the third argument, but it's really unique in another way. One or more of these particular appellees are specifically mentioned in the Court of Appeals opinion from Dallas, and words like egregious and extraordinary are used, and extraordinary is not used in a good way with respect to some of the actions of Ms. Blue and Mr. Lynn. And the conspiratorial part of it we can talk about in a minute. The trial court, when the Court of Appeals looked at it, they concluded that, quote, the trial court had discretion to determine that Hill not only overcame the presumption of regularity, but presented clear evidence he was indicted in retaliation for the civil litigation involving his father and or his former attorney. It's not a passing mention of these folks. It's a detailed account of their involvement. And it's hard to imagine how the trial court in this case, came to the conclusion it did and dismissed the case. In order for Judge Sandell to have done that, he would have to have concluded that the trial court that Hill's purpose was not to bring a meritorious lawsuit, but rather was designed to chill First Amendment rights. And it's hard with this record and what the superlatives used and the details of this involvement, how that could be how in fact anyone could conclude that the purpose that Mr. Hill had in getting his day in court was somehow to abridge or to quell any First Amendment rights. And from the record and these facts, that just doesn't seem right.
That's not quite the test, is it? It's not in the future. It's, are you suing for acts that were committed?
Right, and the Court of Appeals,
First Amendment rights. It's not prospective. It's retrospective.
It is, and the retrospection though is looking at this malicious prosecution case. Is there some attempt to somehow abridge what rights people have under the Constitution? And that's not what happened here.
Well, are campaign contributions protected under the Constitution?
Well, Your Honor, that you raise a great question. I think the Texas Citizens Participation Act has a broader concept of First Amendment rights than the Constitution. I'm not criticizing it. I just think that's what you have to deal with as the judges in this case. And it really hit me. I'm not saying that we shouldn't go through the analysis of the TCPA. I question it because just logic tells me that common sense tells me that taking those examples of speech, association, and what have you, that it's a pretty low threshold to get into the TCPA here. I get a sense that it's been overused, and I think that this is not for this court, but the legislature certainly has amended this. We're not subject to the amended TCPA, but it seems like they're trying to tighten the reins a bit. I'm not so sure they shouldn't go further. And I want to answer.
Setting aside the policy of the
Yes.
TCPA, which I imagine there are several members of the judiciary and of the bar who would like to see it modified to some extent. Let's go into the details of this case. In particular, there are 5,000 pages of documents. There were objections made by the defendants to the admission of those documents, and those objections were sustained. And what effort have you made to parse out, to set aside which of those documents are the subject of those objections and which are not? And how can we tell looking at 5,000 undifferentiated pages?
Your Honor, the only thing you can do is in the record, I'll point you to two things. I don't know the record site, but it's there. 110 pages of objections were filed. In response, Hill's counsel filed a 250-page document that's addressed every single one of the objections, answered it, and had a much like you would see in a trial proceeding, a place for the court to either sustain it or overrule it. And none of that was ever addressed. The only thing that was done is a one sentence, all objections are sustained. So it's difficult to know what the judge was thinking, when that's the effort that was made to deal with these. But we certainly
he was sustaining the objections.
He has sustained 110 pages worth in one sentence.
Right. So you know what he was thinking. He was sustaining all of the objections.
Correct.
And because the intent of the court, the court acts by written orders. We have his written order sustaining the objections. Now, which of those 5,000 pages is subject to those objections?
Well, I'm not sure I can point to the pages, but I think it's more about, it was certainly the declaration, much of the declaration of Mr. Hill. Again, if you look at the 240-page document, it'll tell you every single objection, and what we thought the right outcome was, or should be, from a sustaining or overruling perspective, and that just never was addressed in the proceedings. So it's hard to know how do you appeal from a blanket of sustaining of 110 pages of objections that the underlying party has tried to address them one by one, but the court did not.
Well, I mean, respectfully, Mr. Antwile, at least for our purposes, you addressed them by specifically briefing that for us and telling us, the trial court sustained these objections improperly, and here's why. But that doesn't seem to be the way that your briefing comes across. So then we're just left with combing through everything and and apparently going back to some sort of 200 pages that's in the.
Your Honor, it is a de novo review, and I guess we could have it's in the record, at least what the objections were and what the response was. And so you can see in one document what those were and to what extent. And I'm not sure it's that many documentary objections. It's more about primarily, frankly, it was Mr. Hill's affidavit and supporting documents with that. But you're right. We didn't, and I don't know that that's even a proper response. I'm not what you're saying, obviously, but what the judge did is in a one sentence response. How do we don't know what he just sustained them all. I mean, how do we know how do we address that? Do we have to point the court to every single one of the objections and beyond what we already did and what's in the record to show this court what in fact was dealt with? I don't know how we can do much more than that.
Well, I have another question. If it's okay, I'm going to switch gears a little bit.
Sure.
Since your clock is ticking. Speaking of evidence, what is the clear and specific evidence as to Tillotson, Aldous, and Maloof that they themselves commenced or caused this prosecution? Your
Honor, conspiracy is not a cause of action. It is an allocation of fault. And the clear and specific evidence is, and I just want the court to know this, and it'll be easier for you. We filed what I would call hearing exhibits. In the earlier case that you heard, they did the same thing, and it speaks to all the evidence that supports each of the allegations with specific references to the quote and where it comes from in the record. And it's not new to this court. It's just an easier pathway for you to be able to find and address to answer those questions. There are three exhibits, and one of them, the first one is all elements of the clear and specific evidence of requirements for a malicious prosecution claim and their involvement. But to specifically answer your question as to Maloof, there are specific references to in the timing of which is suspect of their involvement mainly by way of political contributions in support of the efforts that were undertaken by Blue and others to convince this district attorney to do what he did.
So do you have a prima facie case for malicious prosecution against each of the five appellees? Or are you sort of mixing and matching and saying they're all liable for each other's acts and it all adds up among the various sundry acts of the five appellees? It adds up to malicious prosecution.
Sorry to interrupt you. I would answer that with respect to Blue and Lynn. I think there are specific allegations in the record of prima facie showing of their specific involvement. And to a lesser extent, the other defendants, but in a conspiratorial way where they were involved in making these contributions for the sole purpose of helping the cause that Blue and Lynn undertook on behalf of Al's father. I mean, that really is their involvement.
So it's the timing of the political contributions.
Correct. I mean, the timing of them, the communications between the parties, at the time it was happening. In other words, you can't take these contributions and you shouldn't take them in a vacuum. You ought to look at the surrounding circumstances. They had never, I think the record indicates they'd not made contributions to to the DA before. And it was all seems to be tied to the efforts that, as I just described them with Blue and
but other than your concern about the timing, I mean, they were legal political contributions as far as that's concerned. Your complaint is just of the timing of an otherwise legal political contribution appropriate.
I would say in the purpose and intent of doing so in the look, again, you can look at it in a vacuum and describe any political contribution as being legal. I get it as long as it is, but if it's for a purpose that violates the law, then it's not legal in that sense. And our argument is these, while smaller players, they help the cause, and for that reason they participated in the underlying malicious prosecution. My time is up.
I have one factual question, just
Yes,
from the record. Had Hill 3 already paid back the $500,000 mortgage loan prior to the time that Lynn submitted his criminal complaint?
I'm not sure. I know the answer to that right now. I think so. And I know I've seen it in the record when it was done, but I don't. And Mr. Bushy may know. And on reply, maybe he can answer that, and I'll look for it and try to let him know. But I believe it had been paid back before. I believe.
All right. Thank you very much, Mr. Antwile.
Thank you.
Mr. Martin is up next.
May it please the court. Want to respond very quickly to Justice Hightower's question. I don't know the answer either, whether the loan was paid back before the report before the complaint was made. But I do want to address also Justice Kelly's question. Campbell, Harrison, and Dagley and the other defendants were dismissed and non-suited from the case before the TCPA motions were ruled on. That's the answer to that question. I want to also address Justice Countess's question that she's asked today and that she also asked back in October in the 419 case, and that has to do with the record issues. And I want to talk about that because I think it's really important. And I'm going to ask the court if I could refer to the oral argument exhibits that Mr. Antwile referred to that were filed, 5 o'clock on MLK Day. And if the court has had a chance to look at them, I've not had a chance to really go through them, but it's basically 30 pages of single-spaced briefing that would not have been appropriate in a reply brief, much less than 48 hours before oral argument. I just want to point that out first. Second of all, I think it makes sense to look at, if the court has it handy, the oral argument exhibit A. And if you'll turn to page 3, here's a perfect example of the evidentiary problem that we have. Under evidence of procurement, he has here the true nature of the Bordeaux property advance. And he's calling it an advance, and I hope I get to talk about that in a minute. But then he points the court to the declaration of L3, and he cites 16 paragraphs from that 45-page declaration and tells the court that that lists the evidence regarding the true nature of the Bordeaux property, what he calls advance. That's absolutely typical and consistent with the way Mr. Hill has approached this litigation. It's improper, it's inappropriate. The court is not required to go comb through those paragraphs to try to find out what Mr. Hill says that they say. The problem with what Mr. Hill is saying is, and with what he said back in October, is that he's essentially saying that because the TCPA requires the court to conduct a de novo review, that means that you don't, it's completely inconsequential what the objections below were. It's completely inconsequential what the trial court's rulings below were. What this court has to do is look at everything that I say the court should look at and then make a de novo determination as to whether that was properly admissible evidence or not. And I think that's just an incredible interpretation of the TCPA, that it would suspend Rule 33 and the other rules of appellate procedure that require preservation of error.
So standard of review on the evidentiary objections. Are those de novo too?
Well, you've got that case, and I'm trying to remember which one it is. I think it's Baylor, Scott, and White. And that's the case where they point to the Tim Patton law review article where he's saying that, when you're doing summary judgment objections, the court can review those de novo. They don't need to be abuse of discretion. And what the Baylor, Scott, and White court says is we don't have any support for this, but we like that law review article. And so we think that we don't have to do abuse of discretion on evidentiary rulings under the TCPA. Now, it was a different context, because what Baylor, Scott, and White did was the TCPA movement had objected to the TCPA evidence. The trial court had refused to rule. The movement had then objected to the trial court's failure to rule and then raised all that on appeal. And what the Court of Appeals was doing was avoiding having to remand to the trial court to get the trial court to actually rule on the objections. And they said, look, under this Tim Patton law review article, we think we can go ahead and rule on them here. We don't need to send it back to the court to actually make evidentiary rulings, which is not what we have here. As the court's already pointed out, Judge Sandel absolutely ruled. We know what his ruling was. He sustained all the objections. And Hill 3 is just trying to get the court to ignore that. And the court shouldn't. On a similar note, also under oral argument exhibit A, on page 7, you see an entire page of single-spaced writing with full of allegations about Ms. Blue. But then if you look, you see that the main authority for all of these allegations is the trial court's findings of fact and conclusions of law, Judge Lavario's findings of fact and conclusions of law, which we've talked about in the briefing. They're null and void. And as the Dallas Court of Appeals said, they're not to be considered. And Hill 3 hasn't even tried to respond to that in any sort of meaningful way. He just keeps talking about them and pointing the court to them. And that's not proper. And then the third example is from his oral argument exhibit C. On the second page, if you look at footnote 1, in the second sentence, he goes through and he includes a quote in there where he is explaining to the court what Omni American Bank knew and what Omni American Bank didn't know. And he cites his declaration at paragraphs 42 through 43 for that quoted material. But if the court looks at paragraphs 42 through 43, that quoted material is nowhere in that. So the record, the way that Hill 3 is trying to conduct this appeal with this record is just not workable. And again, the court, I think, has picked up on it. And so I'll move on. Hill 3, one of the first arguments he made here in oral argument today was this coverage issue, where he said that what we have to show for coverage is that the lawsuit, the malicious prosecution claim, was quote unquote, I think he said, designed to chill First Amendment rights. I think the court knows by now that the pre-amendment version of the TCPA, that's not correct at all. If it's based on, relates to, or is in regards to or response to, that's sufficient. It requires nothing more than a tangential relation.
What was the legal relationship among Blue, Aldous, and Maloof at the time of these events?
They were co-counsel who had represented Hill 3 against his father and his father's family.
Were they law partners or were they in individual firms?
They were individual firms. And so not to belabor the point on the coverage issue, but I do want to point out that, Hill 3 has made a reference in other cases, in addition to the 419, this case, there's also the 644 over in Dallas, where it's the same arguments are being made. It's just a different group of defendants, and why he split them up, he won't tell us. One might wonder whether he's trying to get conflicting rulings that he can then take somewhere else, but I'll just leave that to Hill 3. And what he's done over in the 644 is the trust is actually the party there. And what I really think is important is that the trust actually, in terms of this not being a true sale, the Bordeaux advance not being a true sale, I think it's important for the court to understand that the trust actually had a receiver appointed and had the house sold.
Let me turn to my earlier question. What finding would we have to make in order to impute Blue, Aldous, and Maloof's actions among each other, to each other? Do we have to say, yes, there was indeed a conspiracy before we can make the imputation to satisfy the prima facie case? Or how do we handle that?
I'm sorry that I'm not going to probably give the court a very satisfying answer to that. I don't think that there's an answer it's just binary. I think the number one thing that has to happen is Hill 3 has to demonstrate have clear and specific evidence as to Ms. Blue. And he does not, because his clear and specific evidence is completely premised on this concept that the Bordeaux transaction was not a quote unquote true sale. And what he says is, I could not have intended to commit fraud or make a misrepresentation because I knew and everyone else knew that this wasn't a true sale. Well, that's not clear and specific. What do you mean it wasn't a true sale? And what he says is, well, it wasn't a true sale because I had a side agreement with my father that said that I got to buy it back within 40 years of his passing. Okay, that's fine, but how does that make that not a true sale? You signed a general warranty deed under penalty of perjury along with your wife that was notarized, and you received over $3 million that you took and spent. That's a true sale. Now, to the extent you had a side agreement, that doesn't change the fact that you absolutely conveyed 80% of your house back in 2004 to your father's trust, and you did not own it in fee simple as you represented to Omni American Bank. And Omni American Bank did not know that, and Hill 3 has no clear and specific evidence that it did. And that's why his case falls apart for malicious prosecution, because he cannot establish actual innocence, and he cannot controvert the fact that there was probable cause for him to be prosecuted for that.
You're coming up on the end of your time.
I am.
Do you want to yield time to your co-counsel, or do you want to continue?
I hate to do this, but I'm going to actually defer to the court. If the court has specific questions about attorney immunity or release, I need to step aside. But if the court doesn't, I can keep going.
I am curious about the attorney immunity. So,
Well, then I'll step aside and let Mr. Koenig take over.
okay, Mr. Koenig, tell us about attorney immunity.
Well, that's a long story, but it's pretty simple in this case. It's undisputed that Mr. Lynn was representing the adversary of Mr. Hill, that is Mr. Hill's father, and at no time was he representing Mr. Hill. It's also undisputed that the only thing he's being accused of doing in this case was filing the memorandum with the DA's office. That is, if you look at the memorandum, which is attached to our brief as Exhibit A, it is clearly a work of legal services that were provided, and it is something that was done on behalf of Mr. Hill Jr., not the plaintiff. Those are the ingredients of an attorney immunity defense. It doesn't, Mr. Lynn does not believe any of the information in the memorandum was false and didn't believe so at the time, but it doesn't matter for purposes of attorney immunity if there was some proof that he believed it was false or that it was false. And that's because the Supreme Court has enunciated a very bright line test for attorney immunity that basically comes down to is a claim by a non-client regarding services that were provided to a client. And if so, you cannot be sued for actions that you take on behalf of the non-client. That's not exactly the legal standard, but that's really what it comes down to.
Does it matter at all that the bank had no complaint about the purported misrepresentations?
No, it doesn't matter. As long as what's being complained about is the provision of legal services to a lawyer's client and not engaging in some outside misconduct. The Supreme Court gives the example of punching another lawyer in court, that kind of thing. That's not part of the rendition of legal services. There can be no question that this memorandum, if you read it, it's a very detailed work of legal scholarship, if you will. It may be right, it may be wrong, but for purposes of the attorney immunity doctrine, it meets the test. And of course, he also has the release defenses, which are separate, and also just depends on the language of the two releases that were.
On a specific factual issue.
Yes, sir.
Hill 3 argues that the 2004 agreement was not really a transfer of an interest in real property because it was not promptly recorded. What is the lack of recordation? What is the effect of that lack of recordation on how that transaction is characterized?
Your Honor, I have to jump in with all the others that I can't answer that question satisfactorily. It's never come up because the inquiry doesn't go that far on the attorney immunity defense. Again, it doesn't matter whether the lawyer is accused of fraud or criminal conduct by the non-client. You are immune if you are accused of something you were doing in the representation of your client. as long as it falls within the scope of what lawyers usually do. It's the nature of the conduct and not how it's characterized by the plaintiff. And I apologize for not being able to answer your question on that. Maybe someone else can.
I have somewhat of a related question. Wouldn't the timing of Mr. Lynn's complaint, which I think that at least in the record is argued was right at the time after the federal court's finding related to perjury, wouldn't that make his complaint a little suspect as far as probable cause as we kind of analyze the elements of malicious prosecution, just the timing of these events?
I don't know that the timing is sufficient. I don't think you look at whether or not it's the probable cause element is related to another motivating event.
Am I correct? It was right after that time, though, that the federal district judge had made that comment, finding, holding.
There was a holding about Mr. Hill Jr., which the court later retracted. And there was a comment that Mr. Lynn had gone beyond the bounds of proper advocacy, which I believe was also retracted later in connection with the settlement.
Is that in our record that it's been retracted, that it was retracted?
I would have to check on that, Your Honor. That's not something we focused on because we didn't have to go there. The releases come after everything that Mr. Lynn is accused of doing is before both releases that were given that expressly refer to all the parties' attorneys except some that were carved out. And so we didn't really focus on the motivation for the memorandum. Unless anyone else has any questions, I will pass it to Ms. Long if there's any time left.
Well, there isn't any time left. Does anybody have any questions for Ms. Long among my colleagues?
That would be specific to Mr. Tillotson, is that right? That's
Correct.
actually, I do have one question.
All right. Then
Is that okay?
We'll get Ms. Long up.
It's actually one that's been asked, but I wanted to ask it specifically. Just, it's a topic we've already been touching on, but to Justice Hightower's questions, what do you make of whether the timing of any donations is a factor or not a factor? What does that mean for your clients?
I think the timing in this situation is very clear, and Mr. Tillotson has a very detailed declaration in the record. It was a campaign contribution year, and he also made that contribution after Mr. Lynn no longer represented Mr. Hill, and the evidence shows that he had no knowledge of any of the underlying memorandums or the disputes with the lawyers. He is an avid supporter of very many political candidates, and there's nothing in the record that ever connects him. And in fact, his declaration shows quite the opposite.
Thank you.
All right. Thank you. Now we will go to Mr. Bushy.
Thank you, Your Honors. I will try to blaze through a couple of these points as I realize I only have 3 minutes. The record site for the objection table that has all the objections and all the responses is volume 9, and that's 5923 through 6148. So that's the table that shows all the objections, all the responses. The question of whether Hill paid back the loan before the indictment, paragraph 37 of his declaration, which is not objected to. Yes, he paid back the loan far before the indictments occurred. And then there's also evidence in the record at the hearing in the criminal court where the DA discussed that the bank did not want to go forward. And she had concerns about being able to prove the case, which we think goes to the element of probable cause. With regards to Aldous and Maloof, specific evidence in the record, there's a June 9th, 2010 email from Aldous to Blue asking, hey, is it time to talk to him about the indictments? or about the charges is what it says. And this occurs on June 9th, 2010. That record site is volume 9, 2797. And
Is that when they she still represented Mr. Hill or afterwards?
no, the fee dispute had already arisen, and the emails on the next page of the record show in emails between Aldous and Blue and all of them discussing how much Hill they want to, you know, possibly settle with Hill about how much they want to take. It's a $50 million that they're discussing, but they're also talking about up to 94 million. So, you know, they had motivation. So that's with Aldous, and that also shows in relation to Mr. Hill's declaration. He talks about when Blue and them represented him, Blue would brag to him about how she had influence over the DA. And you see these emails in there between Blue and her partners that say things like, is it time to talk to him about the indictment? Maloof, there's a record site, volume, I think that's 8. It's 5341 to 5342, and that's from Blue's deposition where she talks about Maloof being at a phone call with Watkins where they were talking about the indictment.
And is
So-
all of that squarely before us though, or are those all things that were objected to and the objections were sustained in the trial court?
Well, those are records, so I'm not sure. They objected mostly to his affidavits, and a lot of the objections are either best evidence or hearsay, which our brief explains we think are improper objections to be making at this stage when you don't have the benefit of discovery to potentially cure any of those. And there's some case law out there that would agree with that. But I can't answer your question as to whether they specifically objected to her deposition transcript, though I would not understand how they could object to her own deposition transcript. The only other thing, if the court would indulge me, is on the eternity immunity doctrine. I would just say it doesn't take a lawyer to file a police report. That's our argument there. It's not within the scope of his representation. And yes, the timing matters because he filed it the day after Mr. Hill's father told him that he would see him in jail because Al 3 wouldn't concede to what Al Jr. wanted. And he told him, I'll see you in jail. And the next day, his father's attorney files that memorandum. And if the court has any questions on the property advance, I'd be happy to address those as well, because that's come up a number of times. There's evidence in this record of what Al 3 told the broker. He was working with a broker as an in-between to get this loan with the bank. And there's evidence in the record, in the declaration, of the specific things he told the broker that the broker was to tell Omni American Bank, including that the transaction existed. And there was a filing in the real property records, not of the deed, because in the contract, in the agreement, the deed was not to be filed. But in the real property records, there was notice that the transaction had occurred. So, and that came up in the title search that Omni American Bank ran. And my client directed the broker to tell them, run a title search to make sure this is clear.
Okay, well, thank you for your argument, Mr. Brushy. This cause, Albert G. Hill III versus Lisa Blue et al., is submitted, and the First Court of Appeals is now adjourned. Thank you very much.
Thank you.
Thank you, Your Honors.
Thank you.